power and privilege, about lawmaking and about law breaking. About race and immigration. It's a story of clandestine crossings, of legal invisibilities, and of legal markings, of the nation's worst moments codified into law, enforced by the piercing surveillance of immigration officials, and buttressed by the steel and concrete of border walls. But it's also a story of possibilities, of resistance to the myopia of convention, of visions of freedom from entangled, persistent permanence of racism. So let's do as the pioneering critical race theorist Derek Bell once said, let's begin. Race infected immigration law from the start. In 1882, Congress enacted the Chinese Exclusion Act, a law that did what its name suggests and wasted no energy trying to conceal its antipathy. But it's easy to deride the past, to put racism in our collective rearview mirror and call ourselves post-racial Americans. To claim that Professor Bell was wrong is easy. To claim that he was wrong when he said that racism is not a permanent feature of life in the United States of America. But ours is anything but a post-racial existence. And when it comes to immigration law and immigration law policing, our laws remain firmly grounded in that explicitly racist past. So let me take us to that legal genealogy. In the 1975 decision, United States versus Brino y Ponce, the Supreme Court identified 6 factors that Border Patrol agents conducting roving patrol stops are allowed to consider when deciding who to pull over. Most are rather mundane, the driver's behavior, for example, but one in particular is not so mundane, and only because it admits so openly to doing what law enforcement officers so often pretend not to do. Justice Powell, writing for the court's majority, explained that Border Patrol officials could take into account the, quote, appearance of a vehicle's passengers. He wrote, trained officers can recognize that characteristic appearance of persons who live in Mexico, relying on such factors as the mode of dress and haircut. As a result, having the wrong clothes or the wrong haircut could render someone who satisfied enough of those other factors suspicious of entering into this country unlawfully. The Brino y Ponce court, however, did not stop at allowing agents to consider clothing and hairstyles when determining criminality. Rather, Justice Powell went on to explicitly authorize agents to consider unchangeable physical characteristics in their calculus. Well, the likelihood that any given person of Mexican ancestry is an alien is high enough to make Mexican appearance a relevant factor. But standing alone does not justify stopping all Mexican Americans to ask if they are aliens. The Supreme Court, however, was not done. 1 year later, the court addressed the proper standard for Border Patrol agents to use when deciding who to order to submit to secondary inspections at permanent immigration checkpoints located in the interior of the country, that is not at the physical boundary that divides two countries. These interior checkpoints are common on highways throughout the border region. Everyone passing through is required to submit to a primary inspection. In United States versus Martinez-Fuerte, the court discussed the criteria for requiring an individual to submit to a secondary, more in-depth inspection, usually at a short distance off to the side of the primary inspection location. The court could not have been clearer that racial profiling in this context was permissible. Well, even if it be assumed that such referrals are made largely on the basis of apparent Mexican ancestry, we perceive no constitutional violation. End quote. The effect on border communities is quite simple. The Supreme Court decisions allowing Mexican ancestry to be linked to suspicion of unlawful presence renders virtually everyone in large swaths of the borderlands suspect. Given the broad reach of the Supreme Court's decisions in Brino y Ponce and Martinez-Fuerte, the reasons used by Border Patrol officials are almost always constitutionally permissible. As these cases illustrate, immigration law is exceptional. Usually, we have to pretend not to be using race. Immigration law is so often a freewheeling field where constitutional norms are shunned, where moral compasses are flipped, and punitive innovations pioneered. Today, there are few better examples of immigration law's exceptionalism than its embrace of imprisonment. The United States, of course, is no stranger to incarceration. For many years, advocates and scholars have been tracking our outsized prison population. They've been identifying its many causes and, of course, prescribing remedies. Those of you who have participated in this series of events are quite familiar with that history. In recent years, perhaps no one has engaged in this conversation more prominently than Michelle Alexander did in her highly influential The New Jim Crow, which I know many of you who are in this room have taken or are currently taking a seminar that is focused on that book. For all that's been said about incarceration, few people, including Alexander, have recognized one subset of the expanding population of people who are locked behind steel doors and surrounded by barbed wire. Those are individuals who run up against the strictures of migration control. To illustrate this, let me focus our attention on a phenomenon that I call immigration imprisonment, that is, locking up people for migration-related conduct. I'll begin by explaining who experiences immigration imprisonment, a population that I call immigration prisoners, not surprisingly. First, on any given day in recent years, there have been roughly 33,000 people detained while the federal government decides if they will be allowed to remain in the United States. These are people who have not been charged with having committed any crime. They're there because they are thought to have violated a requirement of civil immigration law. For example, staying in the United States after their permission to visit temporarily for vacation or for business has expired. And as you can see from this slide, this is a historically unprecedented figure. Over the course of a given year, those 33,000 bodies have made upwards of 400,000 people who were imprisoned in a civil immigration detention center at some point in the course of that year. Not surprisingly, almost all of these are people of color. In recent years, over 90% of these detainees were from Latin America alone. Meanwhile, tens of thousands of others are imprisoned every year because they're thought to have violated a federal criminal law governing migration activity. In fact, immigration crimes, as this slide shows, are now the single largest category of crimes prosecuted in federal court, numbering even more than drug crimes. You can look at the data that I have up there from fiscal year 2012. This is an example. The federal government arrested and booked into criminal custody 85,458 people suspected of committing a federal immigration crime. After conviction, migrants are handed over to the Federal Bureau of Prisons, which on the last day of the 2012 fiscal year imprisoned about 23,000 convicted immigration offenders, I think one of the additional interesting pieces of this data is just how much immigration prosecutions tower over every other type of federal crime that is in the federal penal code. These folks, too, are almost all people of color. These form the federal government's immigration prisoners. Alongside these federal inmates, states are playing an increasingly large role imprisoning individuals for migration-related conduct, and they're doing so in a variety of ways. The bottom half of this graph shows, of this slide shows many, some examples of the ways that states are criminalizing migration-related behavior. Some, for example, are using their traditional police powers, such as by enacting state crimes that target human smuggling or penalizing, criminalizing certain types of misrepresentations about one's identity. Second way that states are engaging in this criminalization of migration-related conduct is by detaining people, especially for especially migrants, detaining migrants in a way that is unique to them and their involvement in migration-related activity. For example, there are some states that have authorized bail restrictions on unauthorized migrants. There are other states that have authorized sentencing enhancements that apply only to individuals who don't have the federal government's permission to be in the United States. All of these, of course, all of these factors, of course, mean that people are behind bars during the course of criminal proceedings. Finally, until very recently, states were agreeing to abide by federal government requests to detain folks beyond the criminal justification to allow immigration officials to decide whether to bring a removal case. Removal cases are simply what most of us refer to as deportation cases. These requests were called immigration detainers. Combined, the federal and state population numbers easily reach more than 500,000 people a year. And though they're sometimes combined by the federal government and sometimes by the states and sometimes by localities, their experiences reflect commonalities that I think make it best to think of this as a single phenomenon. All of these individuals are incarcerated because of some migration-related activity. They would not be detained but for the act of crossing the border or the various actions necessary to survive, such as seeking employment or even something more ordinary like driving a car. In addition, while some of immigration imprisonment is labeled civil and some is labeled criminal, the conditions of confinement in these secure facilities are essentially identical. To house its civil immigration detainees, ICE, the Immigration and Customs Enforcement Agency, a division of the Department of Homeland Security, uses a network of 250 or so facilities spread throughout the United States. Many of these are literally county jails or state prisons that purport to be nothing other than penal institutions. ICE essentially just rents bed space from the county sheriff or the state corrections department. And even ICE's own civil facilities, though, look and feel like prisons. They feature barbed wire, often armed guards, controlled movements. A facility that some of you might have seen in the news in the last month or so illustrates this overlap quite well. For many years, a private prison operator has run a facility in the South Texas town of Raymondville, which is located in Willisey County. Back when I represented clients there, it held civil immigration detainees for ISIS, for folks who were facing possible removal from the United States. And at the time, it was called the Willisey County Processing Center. Then the investigative reporter, Maria Hinojosa, took a team of frontline cameras down there and aired the facility's dirty laundry concerning rampant sexual abuse and other forms of violence. Eventually, DHS moved out its detainees. All of a month later, the Bureau of Prisons began sending their inmates, almost exclusively individuals convicted of federal immigration crimes, to the very same facility. Now it's called the Willisey County Correctional Center. Here's what it looked like then. Here's what it looks like now. It's a little hard to see the difference. We're using the same enforcement method in response to the same migration-related activity across the civil and criminal divide, and across federal and state jurisdictions. I contend, as a result, that we should consider all of the folks who are put into the crosshairs of the government's coercive power because of their immigration status as part of the immigration imprisonment population. Only by looking at this population as a whole can we fully account for the ways in which incarceration is having a pernicious and punitive effect on migrant communities. Let me turn now to how the government achieves the level of immigration imprisonment. To combine so many people, government officials have resorted to a growing panoply of law enforcement initiatives. Though some stem from civil law enforcement powers and others from the criminal counterparts, what's unique about techniques of immigration imprisonment is that the boundaries between these are increasingly becoming less relevant as criminal tactics reflect civil norms and vice versa. The federal government's civil law enforcement powers to detain stem from two provisions of the Immigration and Nationality Act, the federal statute that governs immigration law. One of these provisions is a mandatory detention provision, and another is a discretionary provision. That broad swaths of people are covered by the mandatory detention provision, meaning that neither ICE officials nor immigration judges have discretion to free those migrants from government custody. That itself has contributed to the upward trend in incarceration that I talked about earlier. As detention has grown, however, so too have enforcement efforts that look akin to criminal investigation tools. We see this trend both in the sheer number of ICE and Border Patrol agents, now upwards of 40,000 people stationed across the United States. We also, but I should say primarily along the southwest border. We also see this, though, in the creation of policing initiatives such as the National Fugitive Operations Program that I've listed, which is a program that's specially designed to locate migrants who have failed to leave the United States after having been ordered to do so. But just as immigration enforcement looks ever more criminal, criminal enforcement has also adopted atypical features applied to migrants, including less formal, less stringent prosecutorial and judicial practices that resemble procedures used in administrative immigration court. For example, to process tens of thousands of cases each year, federal prosecutors and courts skirt standard criminal procedures. Rule 11 of the Federal Rules of Criminal Procedure requires that, quote, the court must address the defendant personally in open court for accepting a guilty plea. There's something analogous to this in almost every state rules of criminal procedure. Despite this requirement, immigration defendants regularly appear en masse, and through the program Operation Streamline, which is depicted here, federal courts agree to process the guilty pleas of as many as 75 immigration defendants at once. Now, they go through the standard plea colloquy with these large groups of defendants, and as inherently occurs, the resulting response is sometimes hard to decipher. In the words of the Ninth Circuit, in one case challenging the legality of Operation Streamline, the court said what resulted and what the judge heard was, quote, an indistinct murmur or medley of yeses. This might ring true to those of you who have ever taken a large law school class. Imagine all 75 of you speaking at once, and your professor's job is to figure out who said what and who said nothing. Without bending normal federal criminal procedures, Operation Streamline could not function. And without Operation Streamline, federal prosecutors could never move so many cases through the federal courts. A similar phenomenon has occurred at the state level. For example, the one section of Arizona's infamous Senate Bill 1070, the so-called Show Me Your Papers law that I'm sure many of you, or not all of you, are familiar with, the one section that survived the constitutional challenge requires police to check the immigration status of people who they suspect lack authorization to be present in the United States. This departs from typical practice under which state police would only be investigating violations of state criminal law and vastly increases the contact points through which imprisonment results. The final group of tactics that government officials have used to expand the immigration prison population use resources from one end of that civil-criminal divide to accomplish goals of the other. I'm going to talk about one prominent example. It's a program known as Secure Communities. The Secure Communities Program took biometric identification data, essentially fingerprints, high-tech fingerprints, that were obtained by criminal law enforcement authorities during the course of their standard duties patrolling the streets of every community in this country. And it would take that fingerprint data and shoot it over to the Department of Homeland Security, which would then sift it through their immigration databases. Now this sounds simple, but it actually shook the ground of immigration law enforcement. Through secure communities, ICE could quickly and cheaply scan hundreds of millions of electronic records to identify potentially removable individuals. It did not matter if they were charged with a crime, prosecuted, or convicted. All that mattered was that the police officer scanned some fingerprints and sent them over to the federal government. And of the hundreds of thousands of people taken into ICE custody through secure communities, only a small fraction won their release pending removal proceedings in immigration court. Most were detained for the duration. And the rather extraordinary turn of events, even as it was being rolled out, the Secure Communities Program came under heavy criticism. Last November, Secretary of Homeland Security Jay Johnson announced its demise. That victory was short-lived. In the same memo that announced the end of secure communities, Johnson announced its replacement, the Priority Enforcement Program. And although setting different enforcement priorities, it's clear that PEP will continue to use the resources of the state criminal justice system to feed the pipeline of folks who end up in civil immigration detention at the federal level. Taken together, this type of enforcement tactic, which I think is only properly labeled crImmigration enforcement, has fueled the explosive growth of the immigration prison population. So let me now turn to why imprisonment has become such a core component of immigration law enforcement. Why we have embraced the idea of incarcerating hundreds of thousands of people a year for nonviolent conduct historically thought to be best regulated by civil sanctions and civil sanctions at most. I contend that the answer is two-pronged. It stems both from political considerations and from institutional design. On the political side, for roughly the last 30 years, immigration law has been subsumed under a rhetoric of criminality that frames migrants themselves as the specter of dangerousness. For example, Cubans who left the island from the port of Mariel in the early 1980s were depicted as cast-offs from Castro's prisons, with a U.S. News & World Report headline in 1984 declaring, quote, Castro's crime bomb inside the U.S. This was when U.S. News did something other than just ratings. More recently, Republican Congressman Steve King has re-illustrated this rhetoric of criminality, or did re-illustrate this rhetoric of criminality when he dismissed efforts to provide a legalization path for unauthorized migrants who were brought to the United States as children, the so-called dreamers, by alleging, quote, for everyone who's a valedictorian, there's another 100 out there who weigh 130 pounds and they've got calves the size of cantaloupes because they're hauling 75 pounds of marijuana across the desert. Remember, he's talking primarily about children. Framed this way, it becomes inevitable that confinement will result. Legislators and government bureaucrats are disinclined to release ostensibly dangerous individuals onto the streets. Instead, they have every incentive to tout as an accomplishment the steel and concrete of prison walls and the annual statistics of an ever-growing number of people incarcerated because of a suspected or confirmed immigration law violation. This allows them to show the public that they are doing something about that danger in our midst. And eventually this dangerousness frame begins to build upon itself. Migrants must be confined because they are dangerous, and they must be dangerous because they're confined. Beyond politics, however, the way our criminal and immigration enforcement institutions have been designed also propagates imprisonment. Decades into this project of confinement, immigration imprisonment has now become normal. It has become routine. It has become self-perpetuating, and it has spawned a supportive coalition. Together, this means that immigration imprisonment has become, as I call it, naturalized. This has happened for three interrelated reasons. The first is actually fueled by that political rhetoric of migrant criminality that I just discussed. Having fully adopted that very rhetoric, the Department of Homeland Security has essentially locked itself into a policy of imprisonment. To deviate, it would have to shed its security-laden approach to immigration law that the rhetoric demands. It's, of course, always possible to deviate, but the policy choice they have made has become, as political scientists say, sticky. As a result, DHS chooses imprisonment even in the face of reasonable alternatives. The statute, for example, required DHS to even create the Secure Communities program. In fact, the legislative authorization for the program always remained somewhat murky. DHS pointed to an appropriations bill, congressional budget bill, that funded attempts to, quote, improve and modernize efforts to identify aliens convicted of a crime, sentenced to imprisonment who may be deportable, end quote. Nothing in that language emphasized confinement, and in confinement is exactly what we got. Nothing mentioned taking custody of people arrested, but not charged, charged but not convicted, or convicted but not sentenced to imprisonment, but that's exactly what we got when DHS created Secure Communities. Take another example, the so-called bed mandate. Budget bills stretching back to 2010 have included language requiring DHS to, quote, maintain a level of not less than 34,000 detention beds, end quote. Nothing says that DHS has to fill those beds, yet that's been the department's standard view. Paying for beds that doesn't fill would certainly not be the first time that the federal government pays for something that it does not use. But DHS has made a choice. It has chosen incarceration. A second force has naturalized immigration imprisonment, and that's the natural tendency of institutions to take an expansive view of their own authority. The Justice Department's Board of Immigration Appeals, the highest administrative appellate body in the realm of immigration law, the BIA has taken the view that the word custody, which appears in Section 236 of the Immigration and Nationality Act, custody, which could mean a host of supervisory methods, actually is synonymous with the word detention. And in the process of equating custody with detention, and only detention, the BIA has created what we now know as the mandatory detention provision, which significantly contributes to the enormous civil immigration detention population that I mentioned earlier. Third, immigration imprisonment has become naturalized through the creation of supportive coalitions of third-party actors who now have profit motives around which they lobby for increased immigration incarceration. The most prominent among these are the private prison corporations that derive hundreds of millions of dollars of revenue from ICE, the Bureau of Prisons, and the U.S. Marshals Service for detaining migrants who are awaiting civil removal proceedings, migrants who have been charged, fined in pretrial detention pending federal criminal immigration proceedings, or who have been convicted of federal criminal immigration offense. The Corrections Corporation of America and GEO Group, the nation's two largest private prison operators, respectively, are both heavily invested in immigration imprisonment. The same goes for smaller private prison corporations. For example, the Management Training Corporation has operated that Willis County, Texas facility that I mentioned earlier. First, it did so on behalf of ICE, and now it does on behalf of the Federal Bureau of Prisons. And there's plenty of money to go around. ICE alone spends roughly $2 billion per year, on civil immigration detention. Perhaps more surprising, even local governments are economically invested in immigration imprisonment. That Willacy County facility, actually owned by the county, Willacy County, which contracts with MTC to run the prison. MTC, in turn, contracts with the federal government to house inmates. And the money runs in the opposite direction. The federal government pays MTC, which in turn pays the county. This makes county officials very interested in keeping prison beds filled. After all, without prisoners, the county does not get paid. And local officials are very well aware of this. As the former mayor of Raymondville, Texas said, and this quote that's on the screen, "If we lose our prisoners, the income comes down. We need everyone to be employed. We need those prisoners." There's a fear that in Wilson County, at least, has come to pass. After inmates rose up in opposition to the conditions that they were suffering through about a month ago, Bureau of Prisons removed all of the prisoners. And after the Bureau of Prisons removed all of the prisoners, they removed all of the money that came with all of those prisoners. And after all the money left, so did all of those jobs. Despite this persistent punitiveness, this persistent exceptionalism that immigration law operates under, change, I think, is possible. To say that immigration imprisonment has become naturalized is not to say that it will always be a central feature of immigration law enforcement. There's nothing inevitable about immigration prisons. It may be hard to imagine today, but there's nothing natural about locking people up for the act of relocating. Just as the prison was once naturalized, it can be denaturalized. But if this is to happen, it will be because people like you force it to happen. Law, we know, is a wonderful tool for oppression. It's convenient and it's malleable. It's almost as easy to legislate Chinese exclusion overtly as it is to do so subtly, facially neutrally, so that we flip the morally fraught conduct away from those who legislate fear and onto those who dare flout our rules of law, sheathed as they are in the rhetoric of equality. Law, let us be clear, can be a blunt instrument of indignity and despair. But let us not forget that there's also hope in law. That law can be a radical tool of resistance and a great moral compass. And we are the people who read its directions. We are the automatons who submit to its allure, or the dreamers who imagine law's possibilities, the wordsmiths who shape law's contours and fill in its core with the light of reason, of love, of selflessness. There are the advocates who insist that process is substance, that rules shape outcomes, and that these are fights that must be fought. There are the activists, some with bar licenses and some without, who insist that there is room in law for dignity and justice, and spend long hours searching for creative arguments that can turn the glimmers of hope into realities. Immigration law's ugly history reminds me that we live in a world where the accident of birth so often dictates the fruits that life reaps, where walls and fences, borders, bullets, and wealth so often bring excess to our own plates while denying others the basic necessities of life. Yet those advocates who insist on throwing the wooden shoes of their skills and privilege into the machinery of the state's coercive powers inspire me to dream dreams of freedom about one day living in a world where there are no walls, no prisons, no borders, and no border guards. If this is to happen, it's because you, people sitting in rooms like this, because you cared not only about what the law is, but what the law ought to be. Because you imagined law's impossibilities and then made them possible. Because you refused to learn, or perhaps because you unlearned, that the strictures of law are unassailable commandments from time immemorial. Instead, as the song with which I began this talk says, you insisted on ridiculing the law, on disrobing it of its veneer for the project of social engineering that it is. And in the process of doing that, you insisted on claiming a sense of solidarity with those whose lives you and I will likely never fully understand. The Mexicans who look too Mexican, the clandestine workers trudging through the desert, the prisoners locked up for daring to come here without first receiving the government's permission. If that's to happen, it's only because you cared to make it happen. Thanks for listening. If you want to read more about the topics that I've raised, please consider taking a look at my blog, crImmigration.com, where I write about this stuff all the time.